Welcome to NSG 411, Study Session 10, Nursing Practice and the Law. Introduction. In this study session, we will define law and state its sources. We will also list types of laws and examine relevant laws to nursing practice. Finally, we will discuss the concept of use of standards, negligence. Learning outcomes. When you have studied this session, you should be able to 1. Define law. 2. State the sources of law. 3. List the types of laws. 4. Examine laws relevant to nursing practice. 5. Discuss the concept of use of standards in nursing negligence. Meaning of law. The word law has several meanings. For the purpose of this chapter, law means those rules that prescribe and control social conduct in a formal and legally binding manner. Laws are created in one of three ways. A. Statutory laws are created by various legislative bodies, such as state legislatures or Congress. Some examples of federal status. Take 2. Or Congress. Some examples of federal status include the Patient Self-Determination Act of 1990 and the Americans with Disabilities Act. State status include the State Nurse Practice Act, the State Boards of Nursing, and the Good Samaritan Act. Laws that govern nursing practice are statutory laws. B. Common law develops within the court system as judicial decisions are made in various cases and precedents for future cases are set. In this way, a decision made in one case can affect decisions made in later cases of a similar nature. This feature of American law is based on the English tradition of case law, judge-made law. Many times, a judge in a subsequent case will follow the reasoning of a judge in a previous case. Therefore, one case sets a precedent for another. C. Administrative law is established through the authority given to government agencies, such as state boards of nursing, by a legislative body. These governing boards have the duty to meet the intent of laws or statutes. Status. Localities, state legislatures, and the U.S. Congress create status. This can be found in multi-volume sets of books and databases. At the federal level, conference committees comprising representatives of both houses of Congress negotiate the resolution of any differences or wording of a bill before it becomes law. If the bill does not meet with the approval of the executive branch of government, the President can veto it. If that occurs, the legislative branch must have enough votes to override the veto, or the bill will not become law. Writing to or meeting with state legislators or members of Congress is a way to demonstrate interest in such issues and their outcomes in terms of the laws passed. Passage of a new law is often a long process that includes some compromise of all interested individuals. Administrative law. The Department of Health and Human Services, the Department of Labor, and the Department of Education are the federal agencies that administer healthcare-related laws. At the state level, are Department of Health and Mental Health and licensing boards. Administrative agencies are staffed with professionals who develop the specific rules and regulations that direct the implementation of statutory law. These rules must be reasonable and consistent with existing statutory law and the intent of the legislature. Usually, the rules go into effect only after review and comment by affected persons or groups. For example, specific statutory laws give state nursing boards the authority to issue and revoke licenses, which means that each board of nursing has the responsibility to oversee the professional nurse competence. Types of laws. Another way to look at the legal system is to divide it into two categories: criminal law and civil law. Criminal law. Criminal laws were developed to protect society from actions that threaten its existence. Criminal acts, although directed toward individuals, are considered offenses against the state. The perpetrator of the act is punished, and the victim receives no compensation for injury or damages. There are three categories of criminal law. 1. Felony, the most serious category, including such acts as homicide, grand larceny, and not practice act violation. 2. Misdemeanor, includes lesser offenses such as traffic violations or shoplifting of a small dollar amount. 3. Juvenile, crimes carried out by individuals younger than 18 years. Specific age varies by state and crime. There are occasions when a nurse breaks a law and is tried in criminal courts. A nurse who distributes controlled substances illegally, either for personal use or for the use of others, is violating the law. Falsification of records of controlled substances is a criminal action. In some states, altering a patient's record may be a misdemeanor. Civil law. Civil laws usually involve the violation of one person's rights by another person. Areas of civil law that particularly affect nurses are tort law, contract law, antitrust law, employment discrimination, and labor laws. Quasi-intentional tort. A quasi-intentional tort has its basis in speech. These are voluntary acts that directly cause injury or anguish without meaning to harm or to cause distress. The elements of cause and desire are present, but the element of intent is missing. The elements of cause and desire are present, but the element of intent is missing. Quasi-intentional thoughts usually involve problems in communication that result in damage to a person's reputation violation of personal privacy, or infringement of an individual's civil rights. These include defamation of character, invasion of privacy, and breach of confidentiality. Negligence. Negligence is the unintentional thought of acting or failing to act as an ordinary, reasonable, prudent person, resulting in harm to the person to whom the duty of care is owed. The legal elements of negligence consist of duty, breach of duty, causation, and harm or injury. All four elements must be present in the determination. For example, if a nurse administers the wrong medication to a client, but the client is not injured, then the element of harm has not been met. However, if a nurse administers appropriate pain medication, but fails to put up the side rails and the client falls and breaks a hip, all four elements have been satisfied. The duty of care is the standard of care. The law defines standard of care as that which a reasonable, prudent practitioner with similar education and experience would do or not do in similar circumstances. Malpractice. Malpractice is the term used for professional negligence. When fulfillment of duties requires specialized education, the term malpractice is used. In most malpractice suits, the facilities employing the nurses who cared for a client are named as defendants in the suit. Vicarious liability is the legal principle cited in these cases. Respondent superior, the borrowed servant doctrine, and the captain of the ship doctrine fall under vicarious liability. An important principle in understanding negligence is respondent superior. Let the master answer. This doctrine holds employers liable for any negligence by their employees when the employees were acting within the realm of employment and when the alleged negligent act happened during employment. 10.4 Other laws relevant to nursing practice. Good Samaritan laws. Fear of being sued has often prevented trained professionals from assisting during an emergency. To encourage physicians and nurses to respond to emergencies, many states developed what are now known as the Good Samaritan laws. When administering emergency care, nurses and physicians are protected from civil liability by Good Samaritan laws as long as they behave in the same manner as an ordinary, reasonable, and prudent professional in the same or similar circumstances. In other words, when assisting during an emergency, nurses must still observe professional standards of care. However, if a payment is received for the care given, the Good Samaritan laws do not hold. Confidentiality. It is possible for nurses to be involved in lawsuits other than those involving negligence. For example, clients have the right to confidentiality, and it is the duty of the professional nurse to ensure this right. This assures the client that information obtained by a nurse while providing care will not be communicated to anyone who does not have a need to know. This includes giving information by telephone to individuals claiming to be related to the client, giving information without a client-signed release, or removing documents from a healthcare provider with a client's name or other information. Slander and libel. Slander and libel are categorized as quasi-intentional thoughts. Nurses rarely think of themselves as being guilty of slander or libel. The term slander refers to the spoken word, and libel refers to the written word. Making a false statement about a client's condition that may result in an injury to that client is considered slander. Making a written false statement is libel. For example, stating that a client who had blood drawn for drug testing has a substance abuse problem, when in fact the client does not carry that diagnosis, could be considered a slanderous statement. Slander and libel also refer to statements made about co-workers or other individuals whom you may encounter in both your professional and educational life. Think before you speak and write. Sometimes, what may appear to be harmless to you, such as a complaint, may contain statements that damage another person's credibility, personally and professionally. False imprisonment. False imprisonment is confining an individual against his or her will by either physical, restraining, or verbal, detaining means. The following are examples: using restraints on individuals without the appropriate written consent, restraining mentally handicapped individuals who do not represent a threat to themselves or others, detaining unwilling clients in an institution when they desire to leave, keeping persons who are medically cleared for discharge for an unreasonable amount of time, removing the clothing of clients to prevent them from leaving the institution, threatening clients with some form of physical, emotional, or legal action if they insist on leaving. Sometimes, clients are a danger to themselves and to others. Nurses need to decide on the appropriateness of restraints as a protective measure. Nurses should try to obtain the cooperation of the client before applying any type of restraint. The first step is to attempt to identify a reason for the risky behavior and resolve the problem. If this fails, document the need for restraint, consult with the physician, and carefully follow the institution's policies and standards of practice. Failure to follow these guidelines may result in greater harm to the client and possibly a lawsuit for the staff. To protect themselves against charges of negligence or false imprisonment in such cases, nurses should discuss safety needs with clients, their families, or other members of the healthcare team. Careful assessment and documentation of client status are also imperative. Confusion, irritability, and anxiety often have metabolic causes that need correction, not restraint. There are status and case laws specific to the admission of clients to psychiatric institutions. Most states have guidelines for emergency involuntary hospitalization for a specific period. Involuntary admission is considered necessary when clients are a danger to themselves or others. Specific procedures must be followed. A determination by a judge or administrative agency or certification by a specified number of physicians that a person's mental health justifies the person's detention and treatment may be required. Once admitted, these clients may not be restrained unless the guidelines established by state law and the institution's policies provide. Clients who voluntarily admit themselves to psychiatric institutions are also protected against false imprisonment. Nurses need to find out the policies of their state and employing institution. Standards of practice. Concern for the quality of care is a major part of nursing responsibility to the public. Therefore, the nursing profession is accountable to the consumer for the quality of its services. One of the defining characteristics of a profession is the ability to set its own standards. Nursing standards were established as guidelines for the profession to ensure acceptable quality of care. Standards of practice are also used as criteria to determine whether appropriate care has been delivered. In practice, they represent the minimum acceptable level of care. Nurses are judged on generally accepted standards of practice for their level of education, experience, position, and specialty area. Standards take many forms. Some are written and appear as criteria of professional organizations, job descriptions, agency policies and procedures, and textbooks. Others, which may be intrinsic to the custom of practice, are not found in writing. State boards of nursing and professional organizations vary by role and responsibility in relation to standards of development and implementation. Statutes, professional organizations, and healthcare institutions establish standards of practice. The Nurse Practice Act of individual states define the boundaries of nursing practice within the state. In Canada, the provincial and territorial associations define practice. Institutions develop internal standards of practice. The standards are usually explained in a specific institutional policy. For example, guidelines for the appropriate administration of a specific chemotherapeutic agent, and the institution includes these standards in policy and procedure manuals. The guidelines are based on current literature and research. It is the nurse's responsibility to meet the institution's standards of practice. It is the institution's responsibility to notify the healthcare personnel of any changes and instruct the personnel about the changes. Institutions may accomplish this task through written memos or meetings and in-service education. With the expansion of advanced nursing practice, it has become particularly important to clarify the legal distinction between nursing and medical practice. It is important to be aware of the boundaries between these professional domains because crossing them can result in legal consequences and disciplinary action. The Nurse Practice Act and related regulations developed by most state legislatures and state boards of nursing help to clarify nursing roles at the various levels of practice. Use of standards in nursing negligence. Malpractice actions. When omission of prudent care or act committed by a nurse or those under his or her supervision cause harm to a client, standards of nursing practice are among the elements used to determine whether malpractice or negligence exists. Other criteria may include, but are not limited to, state, local, or national standards, institutional policies that alter or adhere to the nursing standards of care, expert opinions on the appropriate standard of care at the time, available literature and research that substantiates a standard of care or changes in the standard. Patient's Bill of Rights. In 1973, the American Hospital Association approved a statement called the Patient's Bill of Rights. These were revised in October 1992. Patients' rights were developed with the belief that hospitals and healthcare institutions would support these rights with the goal of delivering effective client care. In 2003, the Patient's Bill of Rights was replaced by the Patient Care Partnership. These standards were derived from the ethical principle of autonomy. Informed consent. Without consent, many of the procedures performed on clients in a healthcare setting may be considered battery or unwarranted touching. When clients consent to treatment, they give healthcare personnel the right to deliver care and perform specific treatment without fear of prosecution. Although physicians are responsible for obtaining informed consent, nurses often find themselves involved in the process. It is the physician's responsibility to give information to a client about a specific treatment or medical intervention. The individual institution is not responsible for obtaining the informed consent unless the physician or practitioner is employed by the institution or the institution was aware or should have been aware of the lack of informed consent and did not act on this fact. Some institutions require the physician or independent practitioner to obtain his or her own informed consent by obtaining the client's signature at the time the explanation for treatment is given. The informed consent form should contain all the possible negative outcomes as well as the positive ones. Nurses may be asked to obtain the signatures on this form. The following are some criteria to help ensure that a client has given an informed consent. A mentally competent adult has voluntarily given the consent. The client understands exactly to what he or she is consenting. The consent includes the risks involved in the procedure, alternative treatment that may be available, and the possible result if the treatment is refused. The consent is written. A minor's parent or guardian usually gives consent for treatment. Ideally, a nurse should be present when the physician is explaining the treatment to the client. Before obtaining the client's signature, the nurse asks the client to recall exactly what the physician has told him or her about the treatment. If at any point the nurse thinks that the client does not understand the treatment or the expected outcome, the nurse must notify the physician of this fact. To be able to give informed consent, the client must be fully informed fully. Clients have the right to refuse treatment, and nurses must respect this right. If a client refuses the recommended treatment, a client must be informed of the possible consequences of this decision. Implied consent occurs when consent is assumed. This may be an issue in an emergency when an individual is unable to give consent. All healthcare personnel are accountable for their own actions and adherence to the accepted standards of healthcare. Most negligence and malpractice cases arise from a violation of the accepted standards of practice and the policies of the employing institution. Expert witnesses are called to cite the accepted standards and assist attorneys in formulating the legal strategies pertaining to those standards. For example, most medication errors can be traced to a violation of the accepted standard of medication administration, originally referred to as the 5 rights, which have been amended to 7 rights. 1. Right drug. 2. Right dose. 3. Right route. 4. Right time. 5. Right client. 6. Right reason. 7. Right documentation. Contemporaneous, documenting at the time care was provided. Accurate, documenting exactly what was done. Truthful, documenting only what was done. Appropriate, documenting only what could be discussed comfortably in a public setting. Tips for avoiding legal problems. Keep yourself informed regarding new research related to your area of practice. Insist that the healthcare institution keep personnel apprised of all changes in policies and procedures and in the management of new technological equipment. Always follow the standards of care or practice for the institution. Delegate tasks and procedures only to appropriate personnel. Identify clients at risk for problems such as falls or the development of the cubitals. Establish and maintain a safe environment. Document precisely and carefully. Write detailed incident reports and file them with the appropriate personnel or department. Recognize certain client behaviors that may indicate the possibility of a lawsuit. When a heart ceases to beat, a client is in a state of cardiac arrest. In healthcare institutions and in the community, it is common to begin cardiopulmonary resuscitation (CPR) when cardiac arrest occurs. In healthcare institutions, an elaborate mechanism is put into action when a client calls. Much controversy exists concerning when this mechanism should be used and whether individuals who have no chance of regaining full viability should be resuscitated. Do not resuscitate others. A do not resuscitate DNR order is a specific directive to healthcare personnel not to initiate CPR measures. Only a physician can write a DNR order, usually after consulting with the client or family. Other members of the healthcare team are expected to comply with the order. Clients have the right to request a DNR order. However, they may make this request without a full understanding of what it really means. Study session summary. In this study session, we defined law and stated its sources. We also listed the types of laws and examined relevant laws to nursing practice. Finally, we discussed the concept of use of standards in nursing negligence. End of study session 10 and end of NSG 411. Thank you for viewing.